As we've heard from these conversations, when you think of homelessness, you can't help thinking about encampments. You can't help thinking about people living on the street in encampments. And the Grants Pass decision, which is the subject of our next session. So what I would love to do is bring our featured guest, Deanna Evangelis from Gibson Dunn, as well as my fellow board member and moderator, Steve Sletton.
Thank you, Andrew. Well, it's an honor for me to welcome my partner, Deanna Evangelis, to our symposium this year, and we're going to talk about something we've heard a little bit about from the Lieutenant Governor, and that is the Boise and Grants Pass decisions. Deanna has many accolades and distinctions as a practicing lawyer and appellate advocate, but we are fortunate in that she's also not just the leading authority in the city, but I think in the country on how the United States Constitution bears on some of the issues that our state and local governments are dealing with in the homelessness crisis. And so we're just very delighted to have you here with us today. So let's dive right in. We heard about the Boise decision. Let's start there and tell us a little bit about how you got involved with this issue and with the Boise case, which, as I recall, was filed by several homeless people in Boise, Idaho in around 2009 and ultimately led to a decision out of the Ninth Circuit Court of Appeal in about 2018.
Yeah, that's right. Well, thank you first to all of you. Thank you for all the work that you've been doing for so many years on this issue. Thank you for your leadership, and thank you for inviting me today to speak to you. It really is an honor. I, as you all see, work right here in downtown LA. I've been a partner at Gibson Dunn for a long time now. I graduated from law school over 20 years ago, so I've been a practicing lawyer and an appellate and constitutional lawyer here at Gibson Dunn for a long time. I live in the Mid-City area, so I drive to downtown every day, down 3rd Street or sometimes Beverly. I love Los Angeles, I love California, and my heart breaks every day and I've seen over the past 10 years or so just how much worse the situation has gotten. I became involved on this issue through CCA, the Central City Association, and Gibson Dunn is a member here in downtown LA with a number of other businesses, with service providers on Skid Row. And I started working with CCA on some of these issues because CCA noticed and others noticed that now courts were getting involved and homelessness was becoming the subject of a whole bunch of lawsuits. The city of LA had been sued, the county of LA, other cities all over, but especially here on the West Coast. And it really became a problem. And I remember working with the CCA, and at the time it was 2018, and someone asked me, well, now what are cities going to do in light of the Boise decision that now has constitutionalized, it said that the federal Constitution, and in particular the 8th Amendment, which prohibits cruel and unusual punishment, now applies and cities can't regulate encampments. And I'll be honest, I was shocked when I heard about the decision because it had just come out, and I thought, well, that can't be right. I'd never heard of anything like that before. So I came back to the office and I started researching, and sure enough, the Ninth Circuit Court of Appeals, which covers 9 states, so California, Washington, Oregon, Nevada, Idaho, Arizona, Hawaii, Alaska, it covers a huge part of our country, had issued this decision that said, and the case arose in Boise, Idaho, and there were a group of organizations, ACLU among them on the other side, that sued the city to prevent it from enforcing its camping laws. And the decision said that it would constitute cruel and unusual punishment under the 8th Amendment if cities were to prevent anyone from camping unless there were enough adequate there was enough adequate shelter in the jurisdiction for everyone experiencing homelessness. So what does that mean for LA? I think our latest point in time count in the county is like 70,000. Now, did that decision mean the county? Did it mean the city? Nobody really knew. But what happened was after that decision, 35 lawsuits were filed, and that doesn't count all the lawsuits that were threatened, but 35 lawsuits were filed against cities all throughout the Western United States to really, and they really paralyzed all the efforts. So we heard about encampment resolutions and what they are and what we all want to do. Now, courts are not going to solve this problem. What's going to solve the problem is shelter, housing, interim, permanent, services, all of the work that everyone here is doing. But at the same time, we've seen an explosion of encampments on the street. We know that they're dangerous. We know that people are becoming trapped in them. So the Boise decision immediately had that effect. So I reached out to the city of Boise and offered my services to help them because I knew here in LA that that decision would have the biggest impact on California. And even though it was in Boise, it was going to just really be a disaster for our cities. And it would lead to this paralysis and lawsuits and judges being put in charge of homelessness policy. And we heard from the deputy mayor that this is a complex issue. I don't think any issue is more complex. The intersection of the health issues, the housing issues, mental health, addiction, all of those. And so a court case is not going to solve that problem. And in fact, it will have the opposite effect. So we assembled a broad group of amici, friends of the court, who filed briefs asking the Supreme Court to take that case. Unfortunately, the court did not grant review. It was, in its nascency. The other side said, really, this decision's not going to have an impact. There's nothing to see here. It's not really a big deal. All cities have to do is build shelter and they'll be fine. And I'm oversimplifying, but that was really what they said, is that, they were saying that the city's view that the sky would fall on homelessness policy was wrong, and actually it wouldn't have that effect. So the Supreme Court, for whatever reason, did not step in. I think that's probably not surprising, considering that it was at the time the only decision anywhere in the country, the Ninth Circuit's decision that held that there was a constitutional violation. There was no split among the courts, and there really wasn't, it wasn't known what the impact would be. So sometimes the Supreme Court doesn't wade in, especially on issues this thorny and complex, and they hope that maybe the Ninth Circuit will change its mind. There'll be another case that comes up. Well, we saw what happened. So in the intervening years, we saw, as I mentioned, 35 lawsuits and really a growth in encampments, and increasingly people not getting shelter and services and becoming trapped in encampments, and cities becoming really just powerless to help. What everyone wants here, Steve, and I want to be clear about this. You've maybe heard a lot about this case and this decision, and I just want to be very clear. This case is not about criminalizing homelessness. I know we're going to talk about some of the, what you've heard about it, but I want to be clear about that. Enforcement is a last resort. It is not what anybody wants. It's not going to solve any of these problems. But what city outreach workers need, what all of the city workers who are addressing this problem need, is some ability to help people, convince people really to accept offers of help when they're offered. And I think, we'll also talk about what we've seen in the wake of the decision, but that's what Governor Newsom's message has been: offers of help, and then as a backstop, a last resort, camping regulations that regulate our public spaces.
So you mentioned that the Ninth Circuit is a very large geographical area, and this decision, when it came out, the Boise decision, when it came out, was unique in that no other circuit court had ruled similarly, or maybe on this issue at all. I guess my question is, did other circuits step into this area, or what was the law in other parts of the United States?
Sure, so there had been other decisions on the Eighth Amendment more broadly, and I'm gonna just, I need to explain what the Eighth Amendment issue is, because you're probably all wondering how is the Eighth Amendment usually applies to the death penalty, it applies to life sentences for juveniles and others in certain limited circumstances. It's about cruel and unusual punishment, and as it was put into the Bill of Rights to protect against drawing and quartering, against all sorts of medieval tortures and other punishments that were thought to be barbaric, and the founders wanted to keep them out of the new United States. So that's the history of the Eighth Amendment. It has never applied to what can actually be prohibited in the first place, except for one really unique case, one outlier case from the 1960s from the United States Supreme Court. And that case involved a law in California that made it a crime to simply be addicted to narcotics. So this was Robinson versus California. And the Supreme Court said that you can't make it a crime to simply be addicted because there's no act element. The person hasn't done anything wrong. And as a constitutional matter, that is really punishing someone for their status, for who they are. And so that decision was an outlier. The Supreme Court never expanded it. And in fact, years later, it kind of rolled it back, but there wasn't a majority in that subsequent case, Powell versus Texas. Justice Thurgood Marshall was the one who wrote that opinion and said, well, actually, states and cities can prohibit conduct that they deem to be harmful to public health and safety. And so there, the Supreme Court upheld the law that said public drunkenness was prohibited, and they said that was permissible. It wasn't an Eighth Amendment violation. So I learned in law school, and any lawyers out there learned in law school, that this view of the Eighth Amendment from Robinson was sort of a dead letter, that it had gone nowhere. And throughout history, in the 50 years or so, 60 years actually, since that case, some defendants had tried to argue that they had a compulsion, for example, to possess child pornography, and therefore, those laws prohibiting that were punishing them for their status. Those were rejected by courts. So other courts of appeal all throughout the country had rejected every argument to argue that somehow a law impacted a status. Then comes the Ninth Circuit in the Boise case, and it said, well, actually a law that prohibits camping, and these laws, I'll talk about what they are. They're basic local ordinances. They're civil ordinances in the case of Grants Pass, like a parking ticket. So it's like, regulating where you can park, where you can camp. These laws that are all over the country, the Ninth Circuit said they actually punish someone for their status as a person experiencing homelessness, because that person is camping because you don't have enough adequate shelter, city. So it's really, it's conduct that is somehow excused and not conduct that you can prohibit in any way. And so what that meant is now courts got into the business of saying what shelter was adequate, what wasn't adequate. In joining cities, we saw the city of San Francisco come under a federal injunction. The ACLU brought that case. And it's really interesting, they're advocates who have brought these cases against cities. I know that they are trying to, in their view, they think that they're going to solve the problem through these lawsuits. I have seen the other side of this. I have seen what really has happened, and they've done the opposite of help. They've actually harmed the very people that I think, the groups bringing these suits have wanted to help. I know they mean well, but it really has had the opposite effect. And so, we've seen with care courts also, the lieutenant governor mentioned there's been opposition to those. So there really is a debate going on. There's a debate, but that debate was taken out of our local communities and put into federal courts with the Boise decision. And it meant that federal judges all over the Western United States were now deciding these issues. We had one case, I'm going to give you an example because I think this shows the height of sort of what it means to have courts in charge. There was a case involving San Rafael, California, and I mentioned this in the Supreme Court in my argument when I think this really is a good example. A federal court was handling the case when San Rafael was sued, and the issue before the federal court in San Francisco was whether the Eighth Amendment requires a 100-foot buffer or a 200-foot buffer between tents. And that somehow was the question before, and the federal, judge in that case tried to figure out what was better, got testimony from everyone, but ultimately, these are legislative judgments, they're policy questions, they're really complex. So courts are not well suited to make those judgments, and certainly the Eighth Amendment, which just prohibits cruel and unusual punishment, is not the tool that gives courts the ability to even understand where to draw that line. And so the plaintiff said that 100 feet was the most that the city could impose. The city said 200 feet was necessary because it was becoming unsafe and they couldn't send outreach workers out to help people. So there you have it. That's what was happening.
So we have Boise on the books as of 2018. Let's talk a little bit about Grants Pass. So shortly after the Boise decision, a couple of homeless individuals sued the city of Grants Pass on the same theory, that the municipal code sections concerning camping in Grants Pass to enforce those against the homeless would be a violation of the Eighth Amendment.
Right, and so this happened immediately after the Boise decision. They were sued, and it was a putative class action. So now it was, instead of an individual case, it was some individuals who wanted to bring a class action represented by an organization that was affiliated, again, with the same plaintiffs groups, ACLU and others in Oregon. And Grants Pass, I'd like to tell everyone a little bit about it, is a small city, under 40,000 people in rural Oregon. So I've been there. You fly up to Medford, Oregon, and from there it's a bit of a drive. It's a really charming town. They've had some issues, but really it's a beautiful town. You would never think that, what I saw when I went there, I couldn't believe it. After that decision in the Grants Pass case, the situation began deteriorating, and so I can tell you what it's like and what they've been grappling with. But Grants Pass was sued, and really, just one of the 35 or so lawsuits that I mentioned. And very quickly, the federal court said, now this is proper as a class action, and we're going to assume that everyone camping in Grants Pass is homeless because the city doesn't have adequate shelter. Now, there was shelter in the city, but it was affiliated with a religious organization. And so the Gospel Rescue Mission, which is the name of that shelter, wonderful. I visited it. They're doing great work, but they had certain rules, and the plaintiff said that they did not, wasn't appropriate for them. One of the plaintiffs in the case had a dog who, was not allowed. It was a Rottweiler. It wasn't allowed at the shelter, and she could not. So she said that was inadequate. Another plaintiff said that they didn't like the religious affiliation. The Ninth Circuit Court of Appeals said that when the case got up there from the district court, it said that that shelter didn't count because of the religious affiliation. So the city did not have adequate shelter. Now, when I went to visit, and at the time of the argument, and the shelter submitted a brief to the Supreme Court, the shelter's half empty, sadly, as there are people still trapped in encampments in Grants Pass. And every public park, when I went to visit the city, looked like, it could be Skid Row, it could be the Tenderloin. I was shocked to see this in a rural, small town, really small town USA. And what had happened is that, people were refusing offers of help. The city couldn't limit camping in the parks, and the parks, abutting the elementary school, the children's playground, all of that couldn't be used by the residents of the city. And sadly, the worst part of this, the worst tragedy of all, is that people weren't getting help. So I'm jumping around a lot, but the Thursday before my argument before the Supreme Court in April, I got a call from the chief of police in Grants Pass, and I got to know him. He's really a great person who was doing, outreach first. All of their policies sound a lot like what we're hearing about here in LA. Outreach first, offers of help and services. The camping ordinance was a last resort, and it was a civil ordinance, $75 ticket. It could be increased if, people were repeatedly violating, but really the goal was to get people into help, into addiction treatment, into mental health services. So the chief called me and he said, I just wanted you to know that we had to call off the Little League game tonight because we found a body, we suspect it was an overdose, fentanyl, on the Little League field at 4 o'clock today, and I just wanted you to know we're really hoping that you can help us. And I thought, I mean, the stakes could not be higher, because what we saw in those 6 years from the Boise decision is encampments growing, shelter beds empty. And I know in LA, our numbers are so high and our problem is so enormous. It's not the same as in every other city, but we have to start somewhere. And in cities like Grants Pass, this was really paralyzing the city, and people were not getting help. So, I want to make clear that the city's position here was one of compassion. They wanted to help people, but they had seen their city really overrun by encampments, and they couldn't do anything about it.
So backing up a little bit, tell us how you got involved in the Grants Pass case, and then a little bit about the the path of Grants Pass, because I know there were many voices that came to the court, amicus petitions, amicus briefs, friends of the court briefs. So tell us a little bit about that process.
Sure. So through my work here in LA and in the Boise case, I just became very involved in this world with, getting to talk to many people, meet a lot of local leaders here and throughout the state and all over the country. People would reach out to me on these legal issues. And in the wake of Boise, there were cities getting sued all the time. And so I would get a lot of calls. I was also in the interim appointed to the LA County Blue Ribbon Commission on Homelessness, where I served with Wendy Gruhl. I don't know if she's here yet, but just such a privilege and an honor to serve with her and so many others. And so I stayed involved in these issues. So I was watching the Grants Pass case, and I had talked to their lawyers up in Oregon, and I was kind of giving them advice and talking to them. And then finally, when they got that decision from the Ninth Circuit, they knew that this was, unfortunately, the Ninth Circuit did not reverse on Boise. What it did was double down. It said that not only did the Eighth Amendment apply to the individuals, but it applies now and can be a class action. It also applies to civil ordinances. It applies really to, laws that are on the books from West Hollywood to Watertown, Massachusetts, where I'm from the Boston area. Cities all over the country have these basic laws. So now this was really so much more serious. And I got involved, our firm got involved, and I'm very grateful to Gibson Dunn for its support of our work in this area. And we went to work. Our team filed a petition for rehearing en banc. That means asking the full Ninth Circuit to take another look and reverse course. We gave them another chance to somehow narrow the decision, reverse it. They denied our petition, but we lost by 1 vote only. So it was 17-16. So half the court dissented, and we had hundreds of pages of dissents from judges saying these decisions are harming the very people they were meant to help. All here in San Francisco, outside our courthouse, we're seeing people in encampments overdosing every day. People are dying. People are being victimized. Cities need to have the tools to address this. And what's happened is courts have been put in charge, and this is not the proper role of federal courts. And so there were a lot of judges in the Ninth Circuit who really sounded the alarm. And I think that was key, because then we went to the Supreme Court and we tried again. And so we knew they denied review in Boise, but we thought, now we have this track record. We have 6 years of experience. We've seen what it means for our cities. The numbers were growing. Homelessness, unsheltered homelessness, was rising at enormous rates. And keep in mind, only in the Ninth Circuit, we saw the numbers going up in this Ninth Circuit that was covered by the Boise decision. So city and local leaders and state leaders all chimed in. We had thousands of cities file briefs in the Supreme Court in support of our petition. It's really remarkable. Footnote 3 of the Supreme Court's opinion, if anyone's interested, lists all the cities and the organizations. We had the National League of Cities, National Association of Counties. It was just a remarkable outpouring. Governor Newsom filed a brief in his own name in addition to the state of California. And he said what I think we all believe, which is that no one should call the streets their home. Our goal is to meet everyone where they are, get them shelter and housing, get them services, get them help. But in the meantime, our cities are suffering and people are suffering, and we need to be able to act. And instead of fighting lawsuit after lawsuit, like in San Francisco, where, you know, the mayor of San Francisco and the city asked the Supreme Court to take this case also because they had been hit by an injunction. So you see, you know, I mean, who could be more compassionate than I believe our cities in California, like San Francisco? They're really trying to solve this problem, but even they were getting hit with injunctions by federal courts that made it impossible for them to do anything. So I think that's what made all the difference. So we quickly sprang into action. We got just dozens of amicus briefs that were filed on behalf of thousands of cities. And we had cities outside the West Coast Ninth Circuit file too. We had Providence, Rhode Island, Milwaukee, Albuquerque, cities all over the country that were watching, and they were concerned that this would spread. And so, you know, on the Eighth Amendment I mentioned, there really, the other courts had rejected this big theory, but no other court had been presented really, except for one case that came out of Orlando, where some homeless individuals had sued and the court had rejected the Eighth Amendment claim. And then also the California Supreme Court had rejected a claim many years ago that was similar to the one that was adopted by the Ninth Circuit. So it was really, you know, the Ninth Circuit was still an outlier, but it had doubled down. The stakes were so high because, you know, we just had to get this decision reversed, and the Ninth Circuit wasn't going to do it.
So with all this support, the Supreme Court says, yes, we will take the case, and then the briefing begins. Let me jump to that great day of the oral argument. I mean, as every lawyer who's stood up in court dreams one day of getting to stand in front of the Supreme Court of the United States and argue a case. May it please the court. And so tell us a little bit about that and your experience arguing your first Supreme Court case.
Well, it was an awesome experience, one I will never forget, and the courtroom was packed. The lieutenant governor was there, there were mayors and city attorneys and people from all over who'd come. The public line was filling up at midnight the night before. So it was, you know, there was a lot of attention, there was a lot of media scrutiny, there were a lot of people who were criticizing our position too. But I knew that we were doing this for the good, and that I knew what our city's position was, I knew what our state's position was, and that we really needed to win. You know, the Supreme Court grants about 60 out of 10,000 petitions a year. So the odds were that we'd never even get there. So when we did, it was, you know, so much was riding on it. I did 3 moot courts leading up, practice arguments leading up to the argument. I've argued dozens and dozens and dozens of cases before appellate courts all over the country, but this was my first Supreme Court argument. So, you know, I really studied everything from the history of the Eighth Amendment to all of the amicus briefs. There were 80, about 40 on each side at that stage when we got to the merits. I was really, you know, understanding the policy issues. I had a deep understanding and a deep, I cared deeply about this issue because of all my work on it. So I wasn't just coming in to argue a Supreme Court case. I really wanted to get this win so that we could allow our cities to get back to work and solve this problem in our local communities and not federal courts. So I stood there at the podium. I was supposed to have 30 minutes, but Steve, they kept me up there for over an hour. The questions were just, it was a really hot bench. Every single justice asked questions, at least one, multiple, many of them. The Chief Justice was asking a lot of questions about why should courts be in charge. Justice Sotomayor asked some really probing questions about what does it mean to prohibit someone from camping? What about someone who's just sleeping on the beach? Or what about, there were a lot of hypotheticals. Justice Kagan asked the lawyer for the United States, because when there's a constitutional question, the Solicitor General of the United States and the Department of Justice often gets involved and argues part of the time, and that's what happened here. She was asking, well, what about the plaintiffs in the Grants Pass case argued that it was a biological necessity to have at least a blanket or a tent in order to survive because it gets cold in rural Oregon. And she said, well, what about in places where it's really cold? Or what about, can you have a fire? Can you have a tarp if it's raining? Where do we draw the line? What does the Eighth Amendment have to say about that? So there were so many questions. The argument lasted for over 2 hours. And, at the end, I had 5 minutes of rebuttal. So my top side argument, I really was just going from answer to answer to answer. I could barely answer all the questions because the justices had so many of them, and I did my best. And my rebuttal was 5 minutes at the end, and it's uninterrupted, thankfully. So I really tried to synthesize all of our points and bring it back to the cities, bring it back to how are cities supposed to know if it's 100 feet or 200? How are they supposed to know when their social workers and their teams are going out and trying to address dangerous encampments and get people help? How are they supposed to know what they can and can't do? What does the Constitution require? And there's no guidance for them, and then there's no guidance for courts. And so I thought that those arguments were the ones that resonated the most with the court. It seemed like they were very concerned about the practical implications. And so that 6-year track record under the Boise decision and then under Grants Pass, really, and all of those amicus briefs, they were so powerful.
So I guess, were there any surprises or anything you weren't, I'm sure you're ready for everything, because I know you. But were there any surprises coming out of the argument of the other side that you found interesting or unusual?
Well, I think it was very interesting to see, because the other side, and I'm going to put the Department of Justice on the other side, because really they took a position that the Boise case wasn't wrong, but Grants Pass went too far. So they tried to walk a sort of narrower path, and I knew that as a legal matter, as a constitutional matter, there was no principled basis for making that distinction, because once the Eighth Amendment kicks in, it kicks in, and there's no way to really limit it other than by judicial fiat or some, really just case by case deciding, your best judgment, but that's really not the role of courts. So we thought that their position was a little surprising, and what was most surprising about it is that the federal government itself relies on camping ordinances. So if you go to Washington, D.C., you'll see McPherson Square is, I think, the best example. So the Department of the Interior controls all the parks in D.C., and they, this was very public, they had to address a very dangerous cluster of tents and encampment. It was 70 people or so at its height. And this happened just, a year or two ago, and there had been a murder, there had been many overdoses, there was narcotic dealing, there was sex trafficking, human trafficking, all of those things that we heard that LAPD is trying to address here. That was happening in this encampment in McPherson Square, and so the Department of the Interior issued a bulletin, and it said under the federal code of regulations that it was going to exercise its authority to clear the encampment, and it was going to go about it by bringing in service providers, because, by the way, they weren't able, the rationale the federal government gave was they weren't able to actually get to people to deliver services because it was too dangerous for the social workers. So they were going to exercise their authority to give people notice, and I think it was 48 hours notice there to help them with their belongings. There's a whole process, a very detailed process to get people help and to place people, every person, and give them notice. And if they refuse to comply, the last resort would be that they would be in violation of federal law in that case. I think, thankfully they never had to enforce, because people, once they were presented with that and they knew that they didn't have that option, they accepted the offers. But for months and months, they wouldn't accept them until the government went in and said, now we're giving you your final notice. It was a very unfortunate situation, very dangerous. And, that's mentioned in the Supreme Court's opinion. But the lawyer for the Department of Justice had no response to that, really. And his response was that, well, sometimes it's necessary and courts will be able to, figure it out, because people will just, figure out when it's reasonable. And it was not an answer. And he was really grilled. And I think what showed is that there really kind of was no middle ground here. It was either put courts in charge or not. And our position was get courts out of this. And so, when you're there in a case, I've never had a case like this really where, there are a lot of cases where you have interesting amici. I mean, we had the Attorney General of Texas and Gavin Newsom on our side. So there really was no government, I've never seen that. And So just think about that, but our message was this is not a political issue. It's a humanitarian crisis. It's a policy problem. It's a complex one. What is not going to solve it is 35 lawsuits and counting.
So June of this year, the decision comes out, big day. Congratulations.
Second to the last day of the term.
Second
They saved the best for last.
And a long, much awaited and much anticipated.
Friday, June 28th, but I was getting up every morning at 7 a.m. My husband was there with me starting at like 6 a.m. We were online checking, SCOTUS website every day. It was kind of became a ritual waiting for the decision to come out, but it was very quick. I mean, the case was granted in January, argued April, decided in June. That's lightning speed. So the decision came out in June.
So let's now talk about since June. Tell us a little bit about what we have seen in cities and municipalities in the Ninth Circuit and perhaps elsewhere in response to that decision.
Sure. Well, I have to just say, because you might be wondering what the decision was and the breakdown, it was 6-3. So there was a dissent. There were 3 justices. Justice Sotomayor wrote the dissent. Justice Kagan and Justice Jackson joined her. And the court was not unanimous, but I think among the 6 justices, the opinion written by Justice Gorsuch, it really tracked our arguments exactly. It started on page 1 with the story of the Gospel Rescue Mission and the amicus brief they filed saying that their shelter beds are empty. And it talked about the Ninth Circuit's dissents. And it quoted Governor Newsom's brief repeatedly. It quoted Mayor Breed's brief repeatedly, and the briefs of all these cities and all the amici that filed. So I think that really made an impact, and it was as if the cities spoke and the court listened. I mean, I've never seen this before. The Supreme Court's majority opinion cited those briefs, amicus briefs, 64 times. So I've literally never seen that before, and I've been practicing for a long time. So, then there was a lot of media scrutiny and people criticizing the Supreme Court and saying, this means that the Supreme Court has criminalized homelessness. I hope that you all understand now, after I've described the case and what it was about, that that's the opposite of what happened. What the Supreme Court's decision means is now the issue goes back to our local communities. And LA can have a different approach than Grants Pass or San Francisco, but what it means is that our local communities, our electeds and our service providers and all of us in the community are now responsible. It's not the fault of courts now. It's not anyone else's fault. We have to act. We have to get people help. And so the urgency is still there, but now hopefully we can take action. So we've seen immediately Governor Newsom's executive order in California related to federal property, Caltrans property, and what is the protocol? He has, put forth what he believes is the right protocol for cities to follow involving periods of notice, significant notice to people, pairing them up with offers of shelter and housing and services, and all of those together and as a last resort, pointing to the ordinance. And why is that important? The briefs before the Supreme Court explained, the city of Portland, Oregon said 75% of offers of shelters were being refused under the Boise regime. San Francisco said over 50%. Here in LA, we know LAHSA sends out armies of people over a dozen times before they give up in an encampment, offering shelter and services when it's available. And, that is the tragedy here. So the governor's approach is one that, many, I think, already were following. I think, the Inside Safe program, ultimately what that's about is getting people off the streets. So Mayor Bass's initiative, in LA, we do not have a camping ordinance. The city council suspended it after Boise. So, we don't have anything like that, but city council districts have a protocol that they can go through if there's a dangerous encampment, but it's really up to the city council members' district. And so we see a lot of variation and frankly, a lot of parts of our city still where, it doesn't look like things have changed that much. But San Francisco did see a big shift immediately because they were under a federal injunction, and immediately the court lifted that injunction because it was based on the Grants Pass case. So now San Francisco is able, and Mayor Breed is doing what Governor Newsom has recommended. And so that's what they're doing in San Francisco. And we're seeing whole street blocks that had been taken over, now where people can walk freely and people who had been occupying the encampments are now indoors getting help. And so I think, there is more flexibility, but what this means is really nothing changed in the rest of the country, Steve, because remember, the Ninth Circuit's decision didn't apply. But once the Supreme Court took this case, the stakes really couldn't have been higher, because if we lost, that meant that the Boise decision, the Grants Pass decision, would have been the law of the land. It would have meant that Boston, Chicago, DC, San Francisco, also in LA, no one could enforce any camping laws, including the federal government in DC. So the stakes were really high, but what it means now that we won is that we're back to the status quo before Boise. So we're back to, pre-2018 in terms of the law and the legal restrictions on cities. So we're just back to business, back to normal. It doesn't solve the problem. So the decision's not going to solve the problem. It's up to all of us and our local electeds and our service providers and all of us to solve the problem. But what the good news is that courts are now not in charge. And, we've seen cities who, even the city of Berkeley, California, has found that they need a camping ordinance because in this intervening period, they've seen a growth, an explosion of dangerous encampments, even in Berkeley. So, their policy is going to be the same to offers of help, offers of shelter, lots of notice, but as a backstop, knowing that they have the ability, if an encampment is dangerous, if it's too big, if it's near a school, if for whatever reason, it means that our cities, our public spaces are not safe, and it's gotten to the point where people are dying and they're not, we're not serving them by leaving them there, because that's really what this, comes down to is, does government have the ability to intervene? And we've talked about care courts. I think they're important. I believe in government. I believe government is good. I believe that government can do a lot of good things, obviously in partnership with private partners and all the wonderful organizations. But we need action. So now we can have that, and we're seeing a lot of good happen and a lot of people getting help.
So how about Grants Pass? Tell us a little bit about what the result of this decision had on Grants Pass as a community.
Yes, so Grants Pass as a community, I mentioned every one of their parks, was really overtaken. And so now, the plaintiffs have resolved the case with our local council in Grants Pass. So the decision, it hasn't happened yet, but I'm sure the court will dissolve that injunction, and there's been a resolution there. So there's a process now for putting that into place. But Grants Pass in the meantime has invested in tiny homes. There's since the injunction, because that was a while ago, this has been the law now, they've been, really paralyzed for years, but they have tiny homes. They are building, there's a sobriety center that they built that's really cutting edge, one of the first of its kind and the only one in rural Oregon. So, but they're a very small city. They have budget constraints, and they have trouble funding their schools and their parks and all of these other things. So they're doing what they can, and the people really care, and they want to do. A lot of these are private partnerships, and so they're trying to address the problem. But they've seen really a spike in overdoses, and in Oregon, as many of you know, there was a statewide initiative that decriminalized a lot of narcotics. So that was really the perfect storm with the Boise decision, the Grants Pass decision, decriminalization of a lot of things. So that meant that the points at which government could intervene and could really, do anything to regulate any of this, all of those tools in the toolbox were taken away, and it all happened at once. So it really became quite a bad situation.
Well, I want to thank you for. No, we're not. We're right on time. Thank you for the care that you have and the work that you're doing in this area. I know it's going to continue, and it's been extraordinary having you here today. So thank you.
Thank you. Thank you all.